Afternoon. We are going to do a Facebook live presentation on part of the First Amendment to the Constitution today. We're going to talk about the freedom of assembly and the right to petition government for the redress of grievances. Now, that seems to be something that, when you say those words out loud, the right to assemble, the right to petition the government for redress of grievances, it sounds like something in our time as we're living that, wow, that is, something we should be able to do, or that we are, that it's an inherent part of our liberty. And when we look at the executive decree that came out of the governor's office this week, again, we've got to look at, the Constitution and ask, do you first of all have authority to exercise that kind of power? In other words, does something in the Michigan Constitution or the Michigan laws allow the exercise of power that prohibits people from assembling, people of any number to gather either in a public or a private forum? And for example, the legislature met on Friday in response to some of these actions to set up a committee to oversee executive power. But we, the people, are at this stage are not going to be allowed to even attend those kind of hearings and be heard in person under this order. Under this order, again, as just promulgated and published by the governor Friday again, it would prohibit even a couple of people gathering at a church to set up a live stream sermon by the pastor. And I know that every pastor in the state of Michigan is going to preach a sermon this week, or most of them are, and most of them are going to be using safe technology. They're going to have a couple people there, probably holding a camera and doing what it takes to make it happen. But for whatever reason, perhaps at a time when we need God the most, we're told that 2 or 3 people can't gather in a building of a church to present that message. If it's a different kind of building, however, in Michigan, other buildings, you can, and as long as you're engaging in safe practices, distancing, social distancing, and things like that. My question is, why can't people of faith, why can't Christian people do the same thing in their building that other people can do in a different building? It just makes no sense. Once again, the rules, instead of looking at what is safe and what is not safe, they are picking and choosing who they feel they believe should be essential, and who they think should not, be essential. And it's very clear, unlike a number of other states that have said the church is an essential function, it's very clear here in Michigan the government has said that's not the case. Now, I want to get to the specific provision in the Constitution, the First Amendment, that says, make no law abridging the right of the people to assemble or the right of them to petition the government for a redress of grievances. When my children were very young, and perhaps this is, the burden that a child of a lawyer and a judge has to bear, but my children had a right to petition or appeal appeal, but they had to follow the rules. And if we were in a conversation, my wife and I were in a conversation, for example, and one of our children wanted to come and petition to us, they would have to come up and very respectfully put their hand on our elbow. And when we were finished with our conversation, my wife and I would then turn and listen to their petition. We have, very good, biblical example with Daniel when he was in Babylon, and King Nebuchadnezzar, had taken some of these Israelites, had taken Daniel, had taken Shadrach and Meshach and Abednego, and they had brought them to this foreign land, and they had never been there before. Now all of a sudden they're given this royal food and these this new food that was not part of their free exercise of religious conscience. And Daniel, though, he decided, and no, the Bible said he resolved not to defile himself with the royal food and the wine. But what did he do? He used the power of petition, and he asked the chief official there for permission not to have to defile himself with the food that the king was given, but instead be allowed to exercise his freedom of religious conscience by eating the way that God had wanted him to do. Now, it's interesting because when the chief official, before he went to the king, he said, well, I don't want the king to get mad at me. But Daniel, behind his petition, had facts. And he said, okay, well, just hang on. Let's try it this way. And then watch. You will see that we are not going to get weaker. In fact, we will be strong because we are doing it the way I'm doing it and suggesting. And the petition had supporting persuasive factual truth behind it, solid evidence supporting the petition. And in the end, they were able to see that Daniel was right, and the government at the time, the king, then allowed it to happen. Now, I'm going to come back to Daniel at the end of this talk, though, and talk about a different time when the king much later then commanded the people, including Daniel, not to do something that which God commanded them to do. And, at that point, a petition was not anything that would have been effective. And so I want to talk at the very end of this talk about what happens when, you don't have, some of these remedies that our forefathers so brilliantly put into our Constitution available to you. What should we do then? But let's come to the Constitution now for a moment and talk about that where Congress shall make no law, and the Supreme Court has, rightly or wrongly interpreted that to all government, no government official shall make a law abridging the freedom of speech or the right of the people to peacefully assemble or to petition the government for redress of grievances. Now, when you think of the right of the people to peacefully assemble, I can tell you that the courts over time have kind of woven, or if you've ever, had a big bowl of batter and you're supposed to, put something else into it and you stir it into the batter, what the Supreme Court has done is they've, taken this batter of the right to assemble, and they've kind of stirred it into the right of freedom of speech and the freedom of expression. And so now we have this larger, freedom of expression, but that doesn't mean that the right to assemble, is gone. In fact, I would suggest that it's even stronger than ever. And think about this. Communicating people takes two things. You are listening to me on the end of this live presentation. And so I'm speaking, but then you are hearing, and it takes two people. Now, assembly, that is I can have a right to freedom of speech under the Constitution, and it just takes one person. Now you've got me, and either one of us have this right to hear. Now, assembly, though, you have to have it inherently involves at least two people, and perhaps more. And so I find that interesting that there is a constitutional liberty. And we talk about individual rights, but this is a particular constitutional right that is more of a group right than an individual right. We have a right to associate out of this. And a right to, assemble and petition. Now, again, contemporary Supreme Court decisions have, kind of rolled in all these ideas under a larger freedom of speech, freedom of expression idea, and a right to associate. Why? Well, when you are engaging in speech, that's like me right now giving a talk live on Facebook. That's very different than perhaps organizing a protest or organizing a march or some kind of demonstration. And so the fact that you're associating, that association and that assembling, and again, the Constitution talks about peacefully, the right to peacefully assemble, and assuming that you are engaging all this activity in a peaceful manner. The difference, for example, between Martin Luther King and the way he handled the need to change, bad policy versus Louis Farrakhan and his violent methods. The Constitution protects the type of thing that Martin Luther King did, quite properly does not protect, violent activity like Louis Farrakhan. And so the right to peacefully assemble has been looked at by the courts in a way that creates, beyond the right to assemble, the right to associate. And so there are a number of Supreme Court decisions that strike down government actions infringing on your freedom to associate. And under most of these court holdings, it protects your right to associate with some folks and to not associate with others where you are excluding based on the expressive message of your group. And so, for example, if the government used its power to say that you could not associate because you have ideas that further public policy that say we should not have a monarchy, we should have a republic where we divide power between a legislature and an executive and the judiciary, the government could not use its power to shut you down because of that message. We have a government action here in this state right now that does prohibit us from getting together and associating and assembling even for the purposes of, petitioning the government for redress of the grievances that we perhaps have, not maybe with the specific policy, but I think there's certainly a lot that we could talk about on the specific policy, but maybe even on whether or not, the executive had the authority to issue the order in the first place. For many people, these are issues of good governance and the rule of law, that, we don't live under a monarch. We are not in a monarchy where the person at the top gets to hand down edicts. We live in a representative republic where we divide power between the legislative branch and the executive branch, and we resolve disputes in the judicial branch. That being said, much policy under the edicts and decrees quite rightfully can be debated and be the subject of a demonstration, or a formal type of protest. This right to assemble throughout time has been absolutely crucial, absolutely essential in protecting the minority viewpoint, the dissenting viewpoint. And so it was the abolitionists that needed to rely on the right to assemble in the civil rights era. It is religious organizations today that need the right to assemble. In the past, it's been labor activists and civil rights groups and all sorts of other groups that may not have a majority of the population supporting them, but that may be because they have not been able to hear the other side. And so this right to peacefully assemble provides a constitutional safeguard for perhaps correct, truthful, and good ideas to enter the marketplace of ideas. Well, to be sure, the Supreme Court, hasn't in recent years, looked at the right of assembly and propped it up and set it up on pedestals like we see the freedom of speech in some other places. But I can tell you it's not gone. It is there. It's never been amended. The Constitution has never been amended to remove it. In fact, I would argue that it's enhanced because now it includes concepts of association and expression that are necessarily part of a right to assemble. For the next few moments, I want to talk about the other part of it, the right to assemble, and now the right to petition government for the redress of grievances. I can tell you that since the very first executive order, a number of weeks have been handed down, my email is exploding. My phone rings off the hook. The number of pastors and business leaders and small business owners impacted by these executive orders, they're reading the Constitution and they're calling and they're saying, wait a minute, doesn't the Constitution say this? And why, what can we do? And I've heard all sorts of suggestions on what we can do. Some of them less appropriate than others. Our founders gave us some very, very effective means of addressing the abuse of government power. And again, we've seen these means used very effectively throughout our nation's history and even long before that. The right to petition government for redress of grievances and to peacefully petition the government for redress of grievances, and that was here and part of our nation's DNA, even before, we had colonies. And certainly after we had colonies, and certainly after we had the Continental Congress, and then when we have our current Constitution today. It goes way back to, the Magna Carta, where that included a right to petition, the king. And I can go through the pretty dry history and talk about the English Bill of Rights in 1689 and a number of other things where we only have a limited amount of time, but know that this right to peacefully assemble and petition the government for redress of grievances. That was clear. That was part of the American DNA from the very beginning of our nation, and perhaps, while our nation was in utero before we were even born, it was certainly part of our DNA. Why do we need this? The problem is sometimes, and again, I think we talked about this last week, where Lord Acton, in the 1800s made mention that power tends to corrupt, and absolute power corrupts absolutely. Well, sometimes our public officials, even the ones that we elect, they may, want to listen to their own personal political agenda, and not listen to the people and advance a political agenda at the cost of the people's representatives. They may want to listen to some the lobbyists and those that have disproportionate amount of influence, and as opposed to the citizen. And the citizen's great power is in its Constitution, in our Constitution. That is where we can stand on equal ground with the influence peddlers, the lobbyists, and others, because if we can peacefully assemble in large numbers and petition the government for redress of grievance, exercising our freedom of expression in ways that are peacefully, in ways like, again, I'll talk about Martin Luther King in his peaceful expressions, and his willingness to go to jail, and think of what he accomplished by complying with, by standing up to laws that were wrong, but be willing to take the consequences. And while he was in that jail, he wrote that letter from a Birmingham jail, and that's your homework for this week, is go find the letter from Birmingham jail that Martin Luther King wrote. And there is no wonder that this peaceful assembly with the right to petition the government for redress of grievances, compared to the violence brought upon by people like Louis Farrakhan, it will show you the legacy that those two individuals have. I, for myself, and I pray for all of you, I want to leave a legacy for my children and my grandchildren, that we were fearless, that we stood up to government oppression, and that we stood up to corruption, even if it cost us greatly. I told you that I would finish with Daniel, and there was a great cost that he had when he stood up. And but before I do that, I just want to give you a reality check here on the right to petition. Most court cases, they don't treat the right to petition as the spectacular, fundamental, unalienable right that it is anymore. Again, all of it's kind of more rolled into freedom of expression. And the Supreme Court over time has said, well, one of the ways that we can petition the government for redress of grievances, even though originally it's talking about going directly to the legislature and presenting petitions directly to the law-making bodies and the executive, presenting petitions to the law-making executive, that modern, more contemporary court decisions have kind of looked at the freedom of petition as something that we can do through our court system. And so I know of, I've heard in the last couple weeks, over 900 businesses, for example, that feel very strongly that they have had their constitutional rights improperly infringed upon by the executive actions. I have talked with individuals that represent literally thousands and thousands and thousands of religious people who feel the same way. And I'm guessing that within the next number of days that a number of additional lawsuits will be filed, in addition to the ones that have already been filed, challenging the government actions as either lacking any proper legal authority to be presented in the first place, or assuming that there may be some legal authority. And again, there's no suggestion right now by many that there is. But even if there is some legal authority, the fact that the way that the power was exercised nonetheless violated and infringed upon constitutional liberties of many various people. So I want to probably close here in the last 5 minutes and talk about how Daniel finished up, because this right, to, assemble and petition, according to some in the courts, are not as important as they used to be. I would suggest, given the times that we're living in and the orders that we're under right now, they're more relevant now than they've ever been before, because we're prohibited, literally by law prohibited from gathering in any number, either in a public or a private place. Now, again, to be fair to the state, they are contending they are justified in infringing on our constitutional rights because of the pandemic. There are safe ways to deal with this, and I think we need to stop for a minute and look at these orders and demand an answer that why in one building, if we're being safe and we're 6 feet away and we're wearing our masks, we're not allowed to meet like a church, but if we're someplace else in a different kind of building, for example, an abortion clinic, we're allowed to be there. And so these are questions that we have a right to have an answer to. But what if we don't get the answer we want? What do we do then? And what did Daniel do? Because you saw how he very successfully petitioned the government in my first example with regard to the food. But later we learn that now Daniel has places of position and people are coming after him, and so now those that want to get Daniel out of the way, they convince the king to issue an edict that prohibits prayer and to anyone other than the king. And the penalty was the death penalty in the lion's den. Now, I want to compare that, the cost that David had faced, to the cost that we're facing. If we exercise our right to expression peacefully, and we peacefully assemble, and we do it safely, and we petition the government, and we find ways to do that safely, the cost for us could be a misdemeanor fine. And I suppose for businesses, some larger costs, because there is the cost of they could take your license, I suppose. But for Daniel, Daniel's facing death in the lion's den because he has now been commanded not to do something that God commanded him to do. What did Daniel do? Did he rise up in revolt to overthrow the government? No, he opened the doors and faced the government head on, and he prayed like he always did. He peacefully responded without fear and looked at the government right in the eye, and then paid the cost. And he was thrown in to the lion's den. He faced the death sentence, the cost of following God instead of man. Now, we know the end of the story. God protected him, and when we follow God's precepts at great costs, it wasn't about David surviving, it was about God being glorified. And I think if we look at the world through the lens of God's Word and conduct ourselves in ways that He would have us do, and we use the significant tools that our founders gave us, founders that understood that absolute power corrupts absolutely, we will overcome this current abuse of power. We will overcome this current corruption, and on the other side of it, people will look back at the way we did it, and we will be remembered as someone who, without fear, like Martin Luther King Jr., stood against government oppression, and perhaps at great cost, won. And so my prayer for all of you is that in these times of trial, and I know many of you are facing serious trials right now. I can't tell you how many people have called on the verge of bankruptcy, trying to feed their family, keep their lights on. We will overcome. Be strong, courageous, be fearless, but be peaceful. And until next time, this is Professor William Wagner, and I hope this message has helped. Every blessing to you. Bye-bye.